Hi there, Jack Milligan here, Settlement Professionals. I want to talk today about HIPAA, specifically how to use HIPAA releases to prevent defendants from abusing tort injury clients in your cases. We recently had a settlement where the plaintiff attorney was quite surprised to find out that the defendants in his case had taken his client's medical information and distributed it widely out to 11 insurance companies, annuity issuers, for the purposes of determining whether or not discounted annuities could be purchased, structured settlement annuities, with which to replicate his client's lost income and future medical needs. Why was he so surprised to hear this? Well, because in this particular case, the plaintiff themselves was adamant that no one from the defendants have any involvement at all in the settlement of their case or the placement of any funding vehicles to fulfill any kind of a settlement plan for them, because that plaintiff felt very strongly about not having any involvement with anybody who was connected with the people who caused their injuries. This is a common occurrence. Unbeknownst to that plaintiff and the plaintiff attorney, when they released medical information to the defendants gave it to structured settlement brokers, who then passed it out to the 11 annuity companies, and they obtained what's called a rated age, which is a way of discounting the cost of an annuity so that it yields more or costs less. And in the course of negotiating the settlement to the case, it became evident that even though the plaintiff had requested that the defendants remove their structured settlement brokers from the case and not have anything to do with the settlement, that indeed these people had been retained and had been given private medical information, which is a violation of HIPAA. What is HIPAA? HIPAA is an acronym for the Health Insurance Portability and Accountability Act of 1996. It's public law, number 104-191, and it amends the Internal Revenue Code of 1986. It's also known as the Kennedy-Kassebaum Act. What specifically does it do? Well, amongst many things, HIPAA establishes some pretty strong security standards for protecting the confidentiality of individual medical records. So, how does that affect what we can do to prevent defendants from abusing claimants? Number one, when defendants ask for your client's medical records ostensibly for the purpose of evaluating the case for settlement, the release that you should give them should be so narrow as to prevent them and prohibit them from giving that medical information to anyone who would then further distribute it to insurance companies and put it out into the stream of commerce, as it were. So the release that you give should be narrowly construed to say you're given this release for the purposes of evaluating the case for settlement, but for no other purpose, and you are expressly prohibited from giving this to any agent or broker of any insurance company who might then further distribute it. So what's going to be the net effect of doing this, and why should you care? Well, by prohibiting the defendants from passing your client's medical information out to these insurance companies, you can then have your own expert with a proper HIPAA release give that information to the insurance companies with provisions that they are not to share it with anybody else, so the privacy and integrity of your client's information is protected, and you prevent the defendants from trying to profit off of the injuries they've created for your clients, off the injuries they've caused. You prevent situations where they're able to come in and say to your client at mediation, we admit liability, but with regard to your damages, we disagree on the amount of money you're asking for. We know we can buy annuities from various insurance companies with these discounts that I've talked about due to the fact that they've been injured and their injuries have shortened their life expectancy, creating a discount in the cost. we know we can buy annuities that can replace your losses for much less than the lump sum that you've asked for. Obviously, that very practice by itself makes it difficult for a plaintiff attorney to recover full value for his client. The second area where you're going to benefit by restricting the usage of your client's medical information is if the case doesn't settle and it ends up in court, the last thing you want to hear is that the defendants are putting on an expert who's going to testify as to the cost of an annuity, a structured settlement annuity, which, by the way, except for one annuity company out there, generally is not available for sale to plaintiffs on a direct basis, and there's some reasons for that. I'll get into those in another video cast, but you prevent the defendants from putting on testimony of a discounted cost of an annuity that could be used to replace your client's lost income and provide for their future medical care, information that you probably don't want tainting the jury. So use of HIPAA releases and quoting HIPAA and quoting the penalties involved, which HIPAA has some severe civil and potential criminal penalties for noncompliance, including fines for up to $25,000 for multiple violations of the same standard in a calendar year. And here's the real big one, fines of up to $250,000 and/or imprisonment up to 10 years for knowing misuse of individually identifiable health information. That's some pretty strong teeth in this act. Plaintiff attorneys, I think, would be wise to familiarize themselves with it and obtain a release, a HIPAA release form that they can give to defendants when they ask for clients' medical information that will severely restrict the defendant's ability to shop those medicals through the insurance stream of commerce, and also prevent the defendants from showing up in court and attempting to get a verdict that is much less than the total full value of the case, because they're asking the jury to consider a discounted annuity cost funding mechanism. For attorneys who are interested in pursuing the use of HIPAA releases, my firm has created a HIPAA release that we would love to share with you that should accomplish, or at least will allow you, give you the basis to create your own release to severely restrict what defendants can do with your client's medical information. And then we've also created a revocation of previous releases form, so that if you're in the middle of a case and you think you may have a situation where the defendants are already spreading your client's information out in the insurance company stream of commerce, you can have your client sign a revocation and revoke any of those previous releases. And then when we're given the medicals for your client to use for obtaining these discounted rates, we can also submit that revocation and prevent the insurance company from further sharing that information with the defendant's representatives.